If you watched the last video, the one about durable power of attorney, you might come away with that thinking, I'm covered. And you might be right, but there's one more question worth asking. Does your parents' durable power of attorney cover medical decisions? For most families, the answer is no. And that gap is what we're closing today. A durable power of attorney and a healthcare power of attorney are two completely different legal documents. They both cover two different domains. And most families who are serious about protecting their parents need both. Welcome to Sandwich Generation Life. This channel is for adults raising their children and caring for an aging parent. Today, I'm going to explain exactly what a healthcare power of attorney is, how it is different from the durable power of attorney we covered in the last video, what it allows, and why your family needs both documents. So let's get into it. First, before we start, actually, I am not a lawyer. I am not a legal advisor. Everything in this video is for general information purposes only. The laws and terminology vary by state, and your family situation is unique. Please use this as a foundation and work with a qualified estate planning or elder law attorney for specific circumstances. So let's talk about these two documents. Let me start with a quick recap of what we covered in the durable power of attorney video, because understanding that document is the foundation of understanding why a separate healthcare POA exists. So, the durable power of attorney, sometimes called a financial power of attorney, gives a named agent the legal authority to manage your parents' financial affairs if they become unable to do so themselves. Paying bills, managing bank accounts, handling real estate, filing taxes, managing investments, any financial decision is covered in a durable power of attorney. What it does not cover is key. It does not cover medical decisions. So a financial durable POA has nothing to do with whether your parent receives a particular treatment, who their doctor shares information with, or what happens if they are on life support and cannot speak for themselves. This is an entirely different document, and that is what we are talking about today. A healthcare power of attorney, sometimes called a medical power of attorney, a healthcare proxy, or a healthcare agent designation, depending on your state, is a legal document that names a person to make medical decisions on your parents' behalf if they are unable to make those decisions for themselves. The person named is called the healthcare agent, healthcare proxy, or healthcare surrogate, again, depending on the terminology in your state. But the roles are the same. When your parent is conscious and competent, they make their own medical decisions, full stop. The healthcare agent has no authority. But if your parent loses the ability to communicate or make decisions, whether temporarily or permanently, the healthcare agent steps in and makes those decisions on their behalf. Think about what that actually means. Your parent is in the hospital. The doctor needs to discuss their condition, their treatment options, their prognosis. They need someone to consent to a procedure. They need guidance on how aggressive to treat it. They may need a decision about life-sustaining measures. Without a healthcare POA, the medical team may not be able to discuss your parents' case with you at all, not even with the closest family member, due to privacy laws and other laws that protect the patient. And the absence of a named agent, the hospital may fall back on a default hierarchy that may not reflect your parents' wishes or your family's reality. The healthcare power of attorney removes that wall. It names a person, it gives them legal standing, and it means that when your family is in a medical crisis, someone has the authority to be at the table. So let me put these two documents side by side on the distinction to be completely clear. The Durable Financial POA covers money, bank accounts, bills, taxes, real estate, investments. The Healthcare POA covers medicine, treatment decisions, procedures, end of life care, and who the doctors talk to. The durable POA agent is often called the attorney in fact or financial agent. The healthcare POA agent is called the healthcare agent, proxy, or surrogate. Both documents require your parent to be mentally competent at the time of the signing. Both remain in effect if your parent becomes incapacitated. That is what makes them so important. And both name a trusted person to act on behalf of your family. But they cover completely different territory, and one does not substitute one for the other. Let me walk you through what a healthcare agent is actually authorized to do because people are often surprised by the scope. What they can do is access your parents' medical records and talk to their healthcare providers, including doctors, specialists, nurse, therapists, and facilities. Under normal circumstances, privacy laws would block this. The healthcare POA opens the door. Consent to refuse medical treatments, procedures, surgeries, and medications on your parents' behalf. Make decisions about hospitalization, rehabilitation, home care, care facilities. Make end of life decisions, including decisions about life sustaining treatment, resuscitation, and palliative care. If your parent becomes terminally ill or permanently incapacitated, hire and fire healthcare providers if needed. So, what can a healthcare agent not do? A healthcare agent cannot override decisions your parent made while they were competent, including decisions documented in a healthcare directive or living will. The directive is your parent's voice. The agent carries that voice forward. They do not replace it. The healthcare agent cannot make financial decisions. That is the durable POA's territory. And in most states, a healthcare agent cannot authorize certain specific actions like psychiatric treatment, sterilization, or experimental procedures unless the document explicitly grants that authority. This is why working with an attorney to draft this document is valuable. The language, the specificity matters. A generic form may not cover the situations your family might actually face. Now, choosing the right healthcare agent may be one of the most important decisions your parent makes. This person may one day be asked to make a decision about whether your parent lives or dies, about whether treatment should continue, about what kind of care they receive in their final days. That is not a small thing. The qualities that make someone a good financial POA agent are not always the same qualities that make someone a good healthcare agent. What to look for in a healthcare agent? Someone who knows your parent well, their values, their fears, what matters most to them about their quality of life. Someone who can make hard decisions under pressure without falling apart. Someone who will honor your parents' wishes, even when those wishes are difficult, even when other family members disagree. Someone who can communicate clearly and calmly with medical professionals, and someone who is available, who can be physically present or reachable quickly in a medical emergency. So really someone to me that's local. That would be their best bet. It does not have to be the same person as a durable POA agent. In fact, some families, it makes sense for this to be separate roles. One person handles the finances, the other person handles the medical decisions. That can reduce the burden on any one individual and prevent conflicts of interest. And the durable POA, as with the durable POA, name a backup, a successor health agent who would step in if the primary agent was unable or unwilling to serve. The conversation about who to name can sometimes be harder than the paperwork, especially in families where multiple adult children expect to be involved and where there is history, distance, or conflict. If that is your situation, the most helpful thing you can do is to encourage your parent to think about who truly knows their best wishes, not who is the oldest, not who lives the closest. Well, that debunks my theory earlier. Not who will be the least offended, who will fight for what they actually want, not what everyone else thinks they should want. The process for creating a healthcare power of attorney is similar to the durable financial POA, and in many cases, an estate planning or elder law attorney will draft both documents at the same time as part of a complete estate planning package. So the basics. First, your parent must be mentally competent at the beginning of the signing. Same rule as the financial POA. This cannot be put in place after a crisis has already affected their cognition. Second, the document must be properly executed according to the state requirements. Most states requirements either require either witnesses, notarization, or both. Some states have specific statutory forms for healthcare directives and healthcare agents. Third, the document should be specific. What powers is the agent granted? Are there any limitations? Does your parent have specific values or beliefs that should guide the agent's decisions? The more clear the document, the better. Fourth, once it is executed, make sure the right people have copies. The healthcare agent should have one. Your parent's primary care physician should have one in their medical file. And if your parent is admitted to a hospital or care facility, provide a copy there as well. Fifth, review it regularly. As your parents' health situation evolves, their wishes may evolve too. A document created 10 years ago may not reflect where they are today. Before I close, I want to introduce something that pairs directly with the healthcare POA because understanding how these two work together will make everything clearer. The healthcare power of attorney names a person. It answers the question, who will make medical decisions for my parent if they cannot? But there is a second document, the healthcare directive, also called a living will or an advance directive. That answers the question, what decisions should be made? Your parents' healthcare directive documents that their actual wishes, whether they want life-sustaining treatment in certain circumstances, their preferences about resuscitation, what a good quality life means for them, and what they do not want. The healthcare agent named in the POA uses that directive as their guide. They are the voice. The directive is what the voice is saying. Together, both documents give your family a complete framework for honoring your parents' medical wishes, no matter what happens. We are going to cover the healthcare directive in full detail in the next video. If you have not already subscribed, please do so you don't miss it, because that video is one of the most important ones in the entire series. Let me leave you with this simple summary. Durable power of attorney, finances. Healthcare power of attorney, medical decisions. Two separate documents, two separate agents if needed, and your family almost certainly needs both. If your parent has one but not the other, now you know what is missing. And now you have what you need to do something about it. Talk to an estate planning or elder law attorney. Many will draft a complete package: will, durable POA, healthcare POA, and healthcare directive, one engagement. Getting everything done together is more efficient and ensures all the documents work as a system. If this video has been helpful, share it and leave a comment below. Does your parent have a healthcare POA in place? Do you know who their named agent is? And I want to hear from you. I read every comment, so please drop a comment below. I will see you in the next video where we cover healthcare directive. You will not want to miss it.